I'd like to welcome everyone this morning. Thank you very much for joining us. My name is Buhle Sibanyoni from Legal&Tax, and welcome to our webinar. We have a lot of insightful information to share with you this morning, and I have with me three very lovely ladies, also from Legal&Tax. Firstly, I'd like to welcome Chantal Crinier, who is our head of legal. I have Natasha Ngurume, who is a legal advisor, as well as Nombali Keswa, who is a debt counselor. Welcome, ladies.
Morning, morning.
Morning. How are you doing?
Thank you for having us.
You're welcome. Thank you for joining me. So let's get into it. We wanted to look at understanding contracts as well as contractual disputes. We have kind of put together, information to help you when entering into any sort of agreement, whether it be with a service provider or maybe with an affiliate. So I just want to firstly hear from Chantal. What constitutes a legally binding contract?
So a contract to be binding, both parties need to actually know what they are entering into. The legal word that we normally refer to is there has to be consensus between the parties. So in layman's, there has to be an understanding. So if I'm going to enter into an agreement, I'm going to deliver something and you're going to maybe give me something in return. And so the contract can only be valid if both parties know exactly what is expected of each other. Then obviously there are some other technical issues around that in terms of where it should be in writing, it should be signed by both parties, or if you added certain conditions to say it's got to be endorsed or it's got to be commissioned. But ultimately, the main goal or the main aim of a contract to be valid is to know that both parties know exactly what they're entering into and that they are actually in a position to deliver or carry out whatever the contract is about. So what they say in legal terms, it's got to be, let's say, it's you able to do whatever the task is supposed to be. So say example, I'm going to do a contract with Natasha. She's an attorney. So if I'm going to give her a mandate to say that you need to take this to court for me and you need to defend this certain matter for me, if she's not actually a qualified attorney and then technically the mandate I've entered into, it can't be realized, if you understand what I'm saying. And so when you also enter into a contract with someone, that person needs to be actually in a position to actually carry out whatever you are expecting them to do.
Okay, great. And then obviously, if you've entered into an agreement and you happen to default in terms of making payment, or your account becomes in arrears, and now we're looking at the debt collection side of things. Who exactly regulates debt collectors?
So it's twofold. So normally when it comes to debt collection, it starts with the creditor. So when we take out a loan, we take out a loan from a credit provider. That credit provider needs to be registered with the NCR, the National Credit Regulator. But almost always the creditor is not the one to carry out the collection process. And so that task is normally given to a debt collector, and debt collectors are actually also part of a debt collectors council. So with the bank, they're normally part of the banking association. A debt collector is part of the debt collectors council. And then there's a certain act that applies to them as well. When it comes to banks, we're looking at mostly the National Credit Act, which we refer to as NCA. And then when it comes to the debt collection, there's actually a Debt Collection Act. But each party has their own council, but all of the acts actually combined would apply to that relationship.
Okay, cool. And what are some of my basic rights when it comes to debt collection? What should I know in order to make sure that my rights are protected and I'm not a victim of abuse?
Let me just share a piece of information firstly, because, you know, so we all know that our credit profiles are monitored by credit bureaus. So for every credit transaction, there's a credit bureau. We know them either as TransUnion, ITC, CompuScan, Experian. There's quite a few. And so for every bank that you approach for a loan, that history is obviously, it's captured onto your credit profile. And just to share how everyone is sort of in the same predicament, and that it's not something to avoid or be ashamed of, is that combined data, they call it the Consumer Default Index, that combined data last year in April, that means all of our debt in South Africa for all consumers was 1.5 trillion last year, April. And so I can only assume that because of the pandemic, that has increased. So I think it's very important that whatever I'm going to touch on now is that we all should rather know our basic rights and not get into a position where we kind of ignore the situation and hope it goes away, or it turns out into something better, or they never come for me. But let me just go a little bit into your basic rights. So firstly, like I mentioned, there's the National Credit Act, but there's also the Prescription Act. And so one of the first rules that I think you should look at is when it comes to collection processes, banks are quite slow. And so what you should know is that when it comes to a loan, if a bank has not demanded payment, and say in the form of a letter of demand, a summons, or a judgment within 3 years of your last payment, and during those 3 years you haven't made payment from your side, and you haven't had any conversation with the bank or debt collector acknowledging that you're owing, then technically that loan has prescribed. And so if I can read quickly, it says in section 126B, no person may continue to collect or reactivate a debt under the credit agreement to which the Prescription Act applies. Now, in layman terms, like I just explained, is if no one's done anything from the bank side or debt collector side in 3 years, then technically it's prescribed. And so that means a debt collector, as they do, they would phone you, try and coerce you into paying, or they would send you documents hoping that through intimidation tactics you would be able, or you would make an acknowledgement to pay. But also they're not allowed to go and actually threaten you that you're going to be blacklisted, or even blacklist you on your credit profile. And I think Nombali will go a little bit into that as to how you can correct it, because despite all of these rules, still debt collectors do take chances. They do go and collect on it, and they do unfortunately blacklist people. That act also says that, as normally what happens is, once a loan is prescribed, a bank would normally sell its book. And so they would sell its book to a debt collector. So say a bank has about 100,000 Rand in debt of clients, but all of those loans have expired. They normally sell that book to a debt collector, and then the debt collector still takes a chance. They try and bypass what the NCA says in the Prescription Act. Technically, it is unlawful to do that.
Okay, great. Before we continue, to all our guests that have joined us this morning, I'd like to welcome you. Thank you so much for being with us. We will have an open Q&A session at the end of our webinar. So if you would like to send through questions, please feel free to do so. We have a chat option, so you can simply type out your question, and then we'll get one of our experts to answer the question at the end of the webinar. So yeah, you spoke about credit reports and how to sort of manage your profile and to make sure that you're always in good standing, so it doesn't get to a point where you become a victim of a debt collector. Nombali, can you share with us, how do I obtain a credit record, and how do I make efforts in order to maintain a good credit score?
Thank you, Bushle. So, Bushle, every credit active consumer has a credit record or a credit profile. Now, this is basically information that is stored by the credit bureaus, which basically has patterns, whether negative or positive. It has those patterns that a consumer, as they pay, how are they paying their account, how are they managing their debt on a monthly basis. So basically the credit bureaus have this information, be it TransUnion ITC, be it Experian, CompuScan or XDS, they all have this information. So if a consumer is looking at getting a credit report or a credit record from the credit bureaus, they can just approach them directly and see if they can get that information out of them. But it is your right as a consumer to at least get one credit report for free each and every year from any of these credit bureaus. All right. But as a legal and tax companion, you are also able to get a credit report or a credit record from us. All you have to do is to sign a power of attorney. You return that power of attorney with a copy of your ID, and we'll be able to retrieve that information on your behalf. So this information that you are signing, this power of attorney and the copy of your ID, is basically consent. You are allowing us to go onto your credit profile and retrieve this information. So every credit active consumer, we strongly advise at least once a year, come and get a credit report and see what's happening on your credit profile, so that if there's anything out of the ordinary, you are able to pick that up at an early stage, so that you're also able to deal with such accounts.
Okay, great. And if I am listed on the ITC or I become blacklisted, how do I clear this adverse information?
All right. So if there's any defaults on your credit profile, so as a consumer, as a credit active consumer, there are instances where you are unable to pay your accounts for whatever reason. And now these defaults are on your credit profile. If the account is settled in full, the credit provider has 30 days to update or advise the credit bureaus that this account has been settled in full. If it happens that the 30 days have gone by and the account is still reflecting on your credit profile, which is very common with accounts that have been in default, because for some reason the credit providers are not updating the credit bureaus, or they're not advising the credit bureaus that you are now paying this account. And you'll find that a balance that you had 3 years ago is still appearing on your credit profile. In this instance, you are able to actually lodge a dispute with the credit bureaus. But first, before you lodge a dispute, the credit bureaus require that at least you give them 59 days for the account to be updated from the date that the debt was settled in full and the account was closed, meaning you've got a paid up letter, and the date on that paid up letter, that's the date that they use to count the 59 days. So during the 59 days, 30 days is for the credit provider for them to advise the credit bureaus, and another 29 days is for the credit bureaus to receive this data and actually update your information on the credit bureaus. But in some instances, and actually in most cases, you'll find that this is not the case. You've got this default on your credit profile and the account has actually been settled in full. After the 59 days have expired, then you can approach the credit bureaus and say, this account has been settled in full, here's the paid up letter, and I'd like for you guys to update my profile. If you're a legal and tax companion, it's even nicer because we have in-house debt counselors. We assist in this instance where you send us your supporting documents and we actually lodge the dispute on your behalf. So that's basically how the information is being removed on the credit bureaus. Chantal also mentioned about prescription. So there's also another instance where the account will have to be removed from the credit bureaus, provided that the debt has been extinguished. So it can be extinguished by virtue of prescription. Prescription meaning that it's been more than 3 years that this account has been last paid, and there's just no payment going through, and there's no communication between you and the credit provider. In this instance, the credit provider or the debt collector will have to issue a letter of prescription. This is the same letter that we use to go and update the credit bureaus. Again, in this instance, you have to give the credit bureaus 59 days from the date that the prescription letter was issued for them to update.
Yeah, and Bushle, if I can just add to that and backtrack a little bit. So obviously when it comes to any type of blacklisting, say whether the account has prescribed or it has not prescribed, and now the debt collector is in a position to demand payment, before any legal action in the form of a summons or any notice to the credit bureau to list you, there's a process that you have to be aware of, in which the debt collectors are actually obligated to follow. It all flows into the Debt Collection Act or the National Credit Act. And so what they should first do is send you a letter of demand. In legal terms, we refer to it as a Section 129 letter, but it's like a written document to say, this is your name, this is the account number, and your account is in default, and then they give you a deadline by which you should pay. Now, normally that letter should only be sent about 20 days after your default. It should not be sooner. So that letter, that's the letter you should first receive before the sheriff comes knocking with a summons, or before they list you on any credit bureau profile. Now, when you get that letter, you have about 10 days to respond to that. In those 10 days, you have to either use the opportunity to dispute the account, whether it be on a prescription rule, or you can say that you want to make payment arrangements, or you can approach a debt counselor. Like Nombali said, you can approach one of our in-house debt counselors, and then they are able to take over that burden, contact the creditor or the debt collector, and then try and make payment arrangements. But you should also know that normally it's not just a listing on your credit profile that says you are now a bad default or a bad payment. There's an amount attached to it as well. And so what you should know is that when a debt collector is allowed to now collect, that is, it hasn't prescribed, they can only collect on the capital amount. So that is, if you took out a loan of 500 Rand, they must collect on the 500 Rand. And then they can collect on lawful interest. As we know, all credit agreements have interest attached to it. But you should know is the interest should never be more than the capital amount. So just in short, if you're owing 500 Rand, the interest that's going to be charged should not be 700 Rand. Unfortunately, it is almost always a situation of where you owed 500 Rand and you've left it too long, and now your interest is almost equal to your capital amount, but it should never be more. But a debt collector, unfortunately, if it is a valid loan that they can collect on, they can also add the administration fees and the collection fees. But you should know that these fees are according to a tariff. So there's a tariff that's approved by the Debt Collectors Council. So they can't charge you more than what that tariff allows. And they also cannot charge you these fees if they are not registered with the council. So like your bank, you can only give you a loan if they're registered with the NCR. A debt collector can only collect and add extra administration fees or costs to that if they are registered. And it's quite easy, and we'll be able to share with everyone, but there's a link where you technically can just put in the name of the debt collector and see if they are actually registered. But they're not allowed to add any unless they are obviously registered. And like I said, there's a tariff attached to it. But if I can just go into some very, very important things regarding the debt collection process, is that a debt collector, in terms of the Debt Collection Act, is not allowed to threaten you or present you with any fraudulent or misleading documentation. What we've seen is that they unfortunately go to the consumer's place of work, because this is like the best intimidation tactic. They present you with documents that look like it's been issued from court. They even go as far as to say that you can be arrested because this is a warrant for your arrest. And so you should never, ever, no matter the situation, sign any document before getting professional advice from either a legal advisor or a debt counselor. But you cannot be arrested for a normal loan, like a short-term loan, or a loan that you've taken out with a credit provider. The only time it would actually extend to some criminal prosecution is if it's, say, a maintenance order, which is a whole different type of order and legal obligation towards paying maintenance for a child. But what a debt counselor or a debt collector cannot do, and I'll just read a few from the Act, it says they're not allowed to use force or threaten anyone or you or your family They're not allowed to physically threaten you or your family. And they're not allowed to threaten to give information to your employer, which they do. They're not allowed to serve you with false legal documents, as I've said. They're not allowed to present themselves as police officers or sheriffs or officers of the court, which they normally do. And they're not allowed to threaten or spread false information about your creditworthiness. And they're not allowed to charge more than the fees set down, as I've said, from the council. So those are the most important ones that you have to be aware of.
Okay, great. And if you do find yourself in a situation where you are ambushed by a debt collector, sometimes they do use force, as you've mentioned. How can we assist our members in that regard? What are some of like points that you can share? How can they protect themselves in that kind of situation?
So from a practical point of view, obviously the client can phone into our offices. Normally the debt collectors will visit you during business hours, but if you phone our customer care and you say it's urgent, as the debt collector is there, and then you can obviously phone us, say it's urgent, customer care will put you through to an advisor, and the advisor can actually ask to speak to the debt collector there and then. And so proactiveness is very important for the client to take the opportunity to rather say, you know what, let me just phone my legal or my debt advisor. But in that instance, like I said, never ever admit anything verbally or in writing or sign a document. Do use the opportunity to say that I acknowledge what you have brought to me. You take your copies, but you say I'm not going to sign until I get advice. Now, how we can help you from there is obviously we do a whole investigation. Normally, legal and debt will overlap. We'll do an investigation to see if all the rules were followed by the bank, because we look at record credit, we look at prescription, all the rules were followed by the debt collector. The debt collector is actually registered. So the burden of actually going into first investigating whether this is a legal loan or whether it is an account that you can collect on, that whole investigation process we would do. And through power of attorney, like Nombali explained, if they've already blacklisted you, we would assist in terms of clearing your credit record, but from the legal side, we would be the one to obviously place the debt collector or the bank on terms, write them a letter and get those letters, as Nombali explained, getting the prescription letter or a letter to say that they're writing off the account. But that whole fight that you would normally have to take over, and this is, I think, where people unfortunately withdraw and they just leave and ignore, hoping it'll go away. This is why we are here to assist you. You have to give that burden over to us, because that's what a companion is. We take over that burden and we do that fight for you. Yeah, in a nutshell, that's what we would do.
Right, fine. Thank you, Chantal. And can a debt collector take you to court? Like, has it ever resulted, where somebody has to now appear in court because of a summons or, they're blacklisted, in your experience?
Yeah, so when you're a debt collector and you're only registered with the council, normally the authority would extend to harassing you with the calls, the emails, the SMS and all of that. But when it comes to an actual litigation process, so when I went a little bit into our contracts, not every person can sign a summons and go to court and sue you or defend for you. So you have to be a qualified and admitted attorney. You have to be a member, again, like the bank needs to be a member or the debt collector needs to be a member. We as attorneys need to be a member of the LPC, so that's a Legal Practice Council. And so as soon as a debt collector wants to take it over into a court process, and this is why debt collectors normally come with misleading documents, because many of them aren't qualified attorneys, but they still draft the documents, hoping if you see it, you're going to think that this is a court-issued document. But technically, as soon as you take it over into the litigation process, you have to be a qualified attorney yourself, or you need to obviously be in partnership with a firm, because a firm also has to be a member and pay certain fees to actually litigate. You have to be a practicing attorney. And so if there is any unethical behavior from the bank, normally we would assist you in referring a complaint to the credit or banking ombudsman, depending on what type of complaint it is. If it's a debt collector's complaint, then you can actually complain directly to the Debt Collectors Council, and we can assist with that as well. And if it's an attorney, say even it is an attorney, but they've gone and issued documents on an account that's either reckless or prescribed, and there's some unethical behavior from their side as well, then you can also complain to the LPC, and we would assist in those complaints. And so all of those regulators can actually, they have sanctions which they would apply to each entity, and it's either in the form of withdrawing their license, either paying a fine or demanding that any monies that you paid over be refunded to you. They can issue orders for your credit profile or anything else to be cleared. But like I mentioned, when it comes to a normal loan with a credit provider, there's no criminal prosecution attached to that. But for the bank, or for the debt collector, or for the attorney, it does actually extend to criminal prosecution, because certain actions taken by them, borderline unethical and fraudulent, they can actually be criminally prosecuted for that.
Okay, great. And Nombali, how do I deal with a fraud case? So if somebody has taken my details or an ID number, and they've gone and listed me in all these different places, how do I deal with that? How do I clear my name?
Okay, so fraudulent accounts or identity theft basically means that someone has now taken up your identity, and they're now opening accounts under your name or under your profile under false pretense, pretending to be you. In this case, if you do pick up this information on your credit profile, that is why we advise that at least once a year, do a credit check and just see what's happening on your profile, even if you're not applying for credit. So now there's this instance where you've opened up, this person has opened up this account under your name and on your profile. Immediately, the credit bureaus must be advised of this account. There's documents that you would have to submit to the credit bureaus in a form of an affidavit, where you will state under oath that you don't have any knowledge of this account, you don't acknowledge this account, and it has actually been opened fraudulently under your name. The credit bureau will also require supporting documents such as a copy of your ID. They'll require proof of residence, 3 months bank statement, as well as 6 specimen signatures. So these signatures basically is an A4 document, just a blank document where you will sign your signature 6 times, so that when they investigate if the debt is actually fraudulent, they are able to also compare signatures. So in this case, you would submit that information to the credit bureaus and lodge a dispute. The reason why in this case the 59 days do not apply, where you have to now approach them immediately, is that this person could also be planning to go and open up another credit agreement under your name. So the credit bureaus are able to flag immediately when you lodge a dispute with them. Now, when they get these documents, they then approach the credit provider and advise them that there's a dispute concerning this account, and they give the credit provider a chance to respond to them. And within 10 days at least, the credit provider should have responded to them. If 20 business days go by, the credit provider is not responding, then the credit bureaus is obliged to remove this information from your credit profile. In some instances, the credit provider would come back and raise a defense and say, no, this account cannot be fraudulent. Here is the evidence. In this case, the credit bureaus would then have to investigate and compare this signature, compare your documents, and just check what actually transpired, and then give out a verdict. If you're not happy with the outcome, then the matter can actually be referred to the credit ombudsman, who will then also give you a final verdict concerning this account. But in most cases, 90% of the time, the accounts are actually removed from your credit profile within the average 20 business days.
Okay, great. Natasha, I'd like to, take a step back a bit with you and look at how to cover your bases, how to ensure that you are protected in when entering into an agreement. Can you share with us what are some of the essential elements of a contract that we need to be aware of?
Okay, thank you, Bose. When one enters into a contract, remember, I believe Chantal did mention it. When one enters into a contract, it's between two people. It's an agreement that is entered between two or more people, and the people need to have created an obligation. There are legal obligations and duties that are created when people enter into these contracts. And with the essential elements, the people need to have legal capacity to sign these documentations. For example, you need to be above 18. Yes, that's fine. But also with your mental as well. There's some people at the end of the day that are not mentally stable because of illness, or so they're not able to have the capacity. So there has to be capacity. There has to be an offer and acceptance. And with an offer, it has to be definite. It has to be complete, clear, and certain. And then with an acceptance cannot just be made to A and then B accepts it. No, it has to be accepted by that very person who it's intended to. And it has to be unconditional. And when we talk about being certain, the terms and conditions should not be vague. And this is the reason why sometimes people end up going to court, because court now needs to distinguish what was meant in the contract. So it has to be definite, and it shouldn't be vague. And then also it has to be possible. Every contract needs to be possible. At the end of the day, when you sign something, it shouldn't be providing a service that is impossible. And then also it has to be lawful. We've got cases where people enter into contracts that are not lawful. For example, I'll give an example of where someone cedes their rights when they're not supposed to. Their contract clearly states that you cannot cede these rights, normally the credit agreements. But we have someone who unfortunately has decided to cede their rights because they can no longer pay in terms of the credit agreement. Normally, this is, for example, the purchase of a motor vehicle. Jane can no longer pay, and they sell their motor vehicle to Mary, and they sign a contract to say once Mary finishes paying this motor vehicle, then it becomes Jane's. That's already an unlawful contract on its own. And then there are some contracts, as much as a contract can be verbal. Contracts can be verbal or written. As much as a contract can be either or, there's some contracts that need formalities. For example, an antenuptial contract, it cannot be verbal. It has to be signed. And then we also have the Alienation of Land Act. With that one, you cannot go and purchase a property and just say, look, I'm buying your property, and there's no documentation to that. That is not going to hold in court. And then also with the credit agreement as well, you need to know what you are signing for. So those are some of the formalities. And in a nutshell, there has to be capacity, there has to be an offer and acceptance, it has to be possible, it has to be certain, and it has to be lawful. So those are the essential elements of a contract.
Okay, great. And then what happens if someone doesn't honor the agreement and breaches a contract? What are the repercussions there?
Okay, when people enter into contracts, legal rights and obligations and duties, so to say, have been born. So at the end of the day, if one party breaches and does not carry out in terms of the contract, that is what then becomes a breach. There are remedies in terms of contract law. What we would look at, for example, there will be an interdict where you prevent the person from not performing. You'd have to go and apply at court. You can also claim damages, where if they don't perform, you can claim damages, but you need to prove what damages it is that you have suffered. You can also demand specific performance. For example, where you've taken your motor vehicle to a mechanic and it's staying there for like, let's say, a month, and you've paid the mechanic as well, and this mechanic is not fixing your motor vehicle. We can start, for example, by doing a breach letter where we tell the mechanic you need to fix this motor vehicle. And if the mechanic still doesn't, that's demanding specific performance, because in the breach letter, you'll say, you have had this motor vehicle and you've not yet fixed it. We need you to fix it. so you can demand specific performance. And in some, if it is, for example, exceptional cases where someone has suffered damages, well, everyone would suffer damages in all the above and in all the breach of contracts, but you can also cancel if you've done the breach letters, for example, you've demanded specific performance and the other party is still not coming to an agreement with you. Then in exceptional cases, you can also cancel the contract once they do breach.
Okay, great. And now with May being Workers' Month, what sort of tips or pointers can you share with employees when it comes to their employment contracts with the employer?
Okay, the first thing, okay, with the contract, like I did mention, it can be verbal or it can be in writing. It can be in writing. But in the event that it's in writing, please ask for a copy. That's the first important thing. And what you also need to do is ensure that you know who the parties are that are stated in the contract. You need to know what your duties are. You need to know what services you're going to be giving to an employer and what they are going to be paying you. This is when the salary comes in. Your annual leave applications, because we've had maybe cases where you're told you can't apply for annual leave. So you need to know what exactly it is, what the contract is between you and your employer. And then also, what are the benefits? Is there medical aid? Is there pension fund? And then also, where are you based? Would have issues where someone signs a contract in Joburg, but they don't know where exactly they should be performing at the end of the day. So it's the duties. And also when you're leaving employment, when you want to resign, what notice do you need to give your employer? Some give immediate effect, but you've worked for more than 6 months and you believe that, you know what, it's immediate effect. No, you need to know those terms and conditions. So most importantly, you need to know the duties. There has to be an offer and acceptance. You need to know the parties. They need to be described clearly, because we might have situations where some companies have subsidiaries. You believe you're working for company A, but actually it's company X and your pay slip is coming as company C. So at the end of the day, you need to know who exactly is your employer, your duties. What are your duties in terms of this agreement? Are you supposed to be, for example, let's say a legal advisor, or are you going to be a gardener? What exactly are your legal duties? Because we have cases where someone says, I've been driving for the past 3 years, but what does your contract say? So those are things that should be stated in an employment contract. And also the disciplinary code is also important. So as much as it might not be written, but at least know what the disciplinary code states in terms of your company.
Okay, great. Thank you, Natasha. Chantal, back to you. In terms of a prescribed debt, is there an expiry date, if you may? How long can you legally be chased for a debt?
So, like I mentioned, when you've had a loan with a creditor, if from your last payment or you've never made payment, 3 years have passed since the bank has either demanded it via litigation process or emails or anything like that, but together with those demands, you have also not acknowledged any liability towards it or made any payment within those 3 years, then technically it's prescribed. But remember, in those 3 years, no formal litigation should have been taken in the form of a judgment. And also, it only applies to like your normal loans with the creditor and not like loans where there's a long period attached to it, like your home loan and debts owing to the governmental institutions, like with your municipality rates and tax or SARS or that. That's not the same rule of prescription, doesn't apply, but it's technically 3 years from last payment or no payment without any legal action having been taken and without payment or acknowledgement from your side.
Okay, great. We've had a few cases where debt was written off for a client. So can you take us through what sort of like T's and C's or loopholes you look for in order to, you know, write off any debt, if possible?
Sorry, who did you address there? Nombali or myself?
Oh, no, you, Chantal.
Sorry, I didn't hear that. So it's very rare for it to be written off unless it's prescription from a debt counselor's side. The only other time would be to look into the NCA, the National Credit Act, to see if actually the bank was never supposed to give you the loan in the first place. And that goes into reckless credit. So reckless credit means that the bank gave you a loan, which under your current financial situation, you would never have been able to pay. And so the NCA places a bigger obligation on the bank to do a proper financial assessment. They have to not only just give you a form where they rely on what information you give, because as we know, consumers will make their income is obviously easy. You give a pay slip, but they'll make their expenses a little bit lesser, hoping that bank will give you that loan. But the bank is obligated to look deeper, do a credit profile check, look at your bank statements, all of that. Because unfortunately, like Natasha went into, a lot of clients or consumers just enter into an agreement without really reading the terms and conditions or understanding. And so in your mind, you're getting a 500 Rand loan, but you're not taking into consideration all the fees attached to it, the credit life insurance may be attached to it, or the interest attached to it. And so you haven't done the calculations. And so say the agreement was an agreement that you could have afforded, but the bank hasn't followed all the other rules in terms of making sure you understand your contract and you understand the consequences, the breach clause or anything else where they've gone into detail about making sure that you are giving them informed consent. So like Natasha said, both parties need to know exactly what they're entering into, what's the consequences and what's expected of each party. And so mostly it would go into either prescription, reckless credit, or the CPA, as we would call, makes reference to Consumer Protection Act, where you have to actually just be aware of what you're entering into, and it's got to be conveyed to you in a language or a certain way that you actually understand.
Okay, great. So I see we have a few questions from our clients. I have one that's asking, and I'll direct this to you, Chantal. In a lease agreement of a building, is it lawful to put up a clause that says that the lessee has a right to purchase the property at the end of the lease period or upon the death of the leaser? This means within the lease agreement is it a sale agreement?
So as I understand that, there's a lease agreement whereby if the end of the rental period, the tenant, as we would call them, the lessee or the lessor, so the lessee would normally be the tenant and the lessor would obviously be the owner, that you have the option to buy it. It's quite a practical clause to put in there. And so if I can just go into something though, is that you can never contract out of law. That specifically doesn't go against the Rental Housing Act, which we would refer to, or Properties Act or anything like that. But you cannot contract out of law. And so say that clause was unlawful, then technically it would make the agreement void. But anything other than that, when you want to add a clause which is not specifically provided in an act, but it's to the benefit of both parties and no one's going to be prejudiced, you can technically bring in any clause as long as both parties agree to it. So it's like Natasha said, if there's consensus about it and there's a benefit to both and it's possible to realize, you can add that clause to a contract. But anything else which is contradictory to what the law provides, or like Natasha said, you can't obviously cede your rights or extinguish your rights, then that would make it unlawful.
Okay, great. There's another question, and they're asking, what about contracts? For example, a TV license and e-tolls. Will these impact on one's credit record if you don't pay them?
So e-toll is maybe a subject we must park, because that's been going back and forth, and it's almost as if there's been some sort of debt collection process on that as well, where you get all these articles sending people in a frenzy because they're worried about what's being proposed in terms of taking action against it. And so yes, there's been talks about blacklisting people or summoning people, but as it stands, nothing has happened, and for practical reasons it won't work, which I'm not going to go into. But when it comes to your TV license, currently there is a process to that. So with your TV license, if you have a TV, you're obligated to pay that license. If you don't pay that license, there's actually a normal debt collection process to that. But as I said, when it comes to certain debt, remember now, a loan is a creditor giving you a capital amount, and you have the benefit of it, but you have to pay it back with interest. When it comes to certain governmental debts, it's not money that you're getting and you have to pay it back, it's actually service. So what does the municipalities or SARS or anyone else, like, they give us a service that we have to pay back. And unfortunately, those types of debts have a very long period to where it doesn't prescribe. In certain instances, it's like 30 years. But there's a normal debt collection process to it, even with SARS. There's a debt collection process to it where it's even extended to getting an order against your salary. So the litigation process can still happen regarding that. But the debt collection process, all the rules that apply to the debt collectors will still remain the same, even though the prescription rule won't apply the same to those types of debts.
Okay, great. I have another question for you, Chantal. If a debt is written off on your credit profile, do you continue paying the debt collection agency? Can you explain what is the procedure around that? Is there any commission maybe that you need to pay?
So it depends on what's on your credit profile. And Nombali can also give a view on this, because like I said, sometimes the loan was with a bank, but the bank hasn't taken action, and then they technically send a notice to the credit bureau to say, you know what, we're just going to write this off. We're not going to collect on it. And so on your credit profile, it might reflect as Standard Bank gave you a loan, but it's written off by Standard Bank. So Nombali explained the process on that, but she can go into it again. But what makes it a little bit complicated is that sometimes when the bank has firstly sold that book to a debt collector, and then the debt collector goes and then he obviously starts blacklisting you on the system. Now, in those circumstances, again, it just flows into who's the actual person who gave the notice to the credit bureau and investigating whether the bank took the right recourse or whether the debt collector took the right recourse. But in all instances, never ever pay or acknowledge verbally or in writing until you've received professional advice, because there's a whole investigation process that goes into it. So though I understand the stress of being coerced in being paid or being annoyed with all the calls and all the SMSs, what we do basically from Legal&Tax, whether it be from the legal or the debt side, we immediately place that bank or the debt collector on terms by saying, right, stop communicating with our clients. Here's our power of attorney or our mandate. You must then communicate with us. And if they still bypass and all of that, again, we can actually take the recourse of, reporting them for unethical behavior. And so the best way for you to be helped is, one, be proactive and contact us to take over that burden and tell that person, whether it be a debt collector or the bank, to stop harassing you, and we take over the communication. Or obviously we follow the route of referring the complaint to the regulating body on your behalf.
Okay, great. And Chantal, in terms of a fixed contract, for example, a gym membership contract, if I've entered into that agreement and after a while, as you know how it goes, you want to terminate, is there any way at all that I can terminate that kind of arrangement?
So when it comes to fixed term contracts, when it comes to certain memberships and you're receiving like a service, then normally the CPA, which we call the Consumer Protection Act, would apply. The Act actually places a restriction on the length of a contract. So firstly, we would look at your contract to see, have they made the contract longer than what the law actually allows, whether it be from 12 to 24 months, depending on who the parties are who contracted. But unfortunately, with every fixed term contract, there's almost always a penalty clause for early termination. And what that says is you'll basically, depending on the contract, it would be, say, you've entered into a 12-month contract, but now 6 months into it, you want to cancel. Sometimes, unfortunately, the cancellation clause says, well, for those 6 months, even though you're not going to use the membership, you're going to still have to pay us for those 6 months. So it gets a little bit complicated. So like I said, if it's a membership agreement or it's a cell phone agreement, which is a little bit different because you've actually received a certain item of a certain value compared to services, there is an argument around it in terms of fairness. And so the CPA has said that you have to look at what is fair. So would it be fair for you, given the circumstances, to pay 6 months for a membership if you're not even going to be using it? And technically, there's no loss to the gym. But say you have a cell phone contract, you've received that 10,000 Rand phone, and to expect them now to cancel, and you actually benefit from that, and you want to cancel, not pay the value still back to them, then technically it becomes a little bit more complicated. And so we would look at fairness, and it's a balance of scale. So what was the loss of both parties, and is there a middle ground to make sure that each party is not in a worse condition, if I can explain it like that.
Okay, great. I don't know if we have any further questions from our audience. If you do, please type it in. We've got a Q&A little box that you can type your questions in. But in closing, Chantal, what is the take-home message that you would like to share with everyone in terms of everything that we've discussed?
I think the take-home is just to know that you're not alone. Like, what is the whole purpose and definition of a companion? I mean, times are tough, and so you have this opportunity of having someone to have your back, if I can say that. And so the take-home message is to really take advantage of our services, because we really do care about our clients, and we have this need to really help people. And so you have to be responsible as well, because for me, your actions actually have a ripple effect on your family, your friends, and everyone else. And so if possible, you have to be responsible in terms of making use of our services and taking that step and knowing that someone is going to help you. And so that's my take home.
Great. And Mbali, is there anything that you'd like to share?
Yes, I just wanted to remind ourselves that, or the importance rather, of financial wellness or financial well-being. If we were listening to the last webinar that we had on financial wellness, what it is and why it actually matters, I wanted us to just quickly remind ourselves that financial wellness is that sense of security when we're talking about your finances, that feeling that you have enough for you to be able to meet your living expenses as well as your needs. We also touched on budgeting properly, because it's very important for us to be financially fit, especially in times like these. It's also important that we don't try and keep up with the Joneses, but stick to our budget, stick to our finances, and understand what it is that we need as consumers, so that in future, when we have problems, we do have some sort of a contingency plan. So we need to start saving and start having that contingency plan, so that when we have troubles, we don't actually have to run to the credit providers every time we need some emergency cash. So I strongly advise that we also come to us for credit reports, and make sure that we do those credit checks at least once a year, just to make sure that we keep our records clean. And if we need advice on how to manage our finances better, remember, with Legal and Tax, you're not alone. We are here to assist you. Please make use of our services, and we'll be happy to assist you.
Thank you, Nombali. Natasha, is there anything you'd like to add?
Yes, sure, thanks. When it comes to contracts, the general rule is whatever you sign, you are bound by it. But please do remember that not all contracts are valid. So at the end of the day, even if you've signed a contract, don't be scared to approach us so that we can go through the contract. For example, we do have cases where someone has signed over their ID document or their SASSA card because they've taken a loan from a loan shark. Just because you've signed that agreement, it doesn't mean it's valid. So whatever it is you've signed, do contact us. We are there for you. Thank you.
Thank you, Natasha. Ladies, thank you so much for joining me this morning. You've been very insightful, and if any of our guests want to chat to one of the advisors, please do call us on 0860 587 587. You can also email us on info@legalandtax.co.za. We also have a WhatsApp bot. So you simply type a message, type hi, and send it to 071 526 8527. But it's been great, ladies, as always. Thank you so much. I really appreciate you making time for us this morning. And to all our guests, thank you so much for joining us. I hope you've learned a lot. As I said, it's been very insightful. And if you do want to chat to the advisors further, reach out to us. We are here to be a companion to you, and we definitely care about your well-being. So reach out to us, please make contact with the lovely ladies. But thank you so much. I hope to see you all again in next month's edition. All the details will be sent through via our social media pages, and you'll also receive a personal invitation. And yeah, we'll see everyone back here again next month. Thank you so much. Thank you, ladies.
Bye.
Thank you. Bye.
Bye.